another sort of hot button issue is the Texas abortion law. It came before the Supreme Court. So the background of it was Texas passing a abortion law that basically prohibited abortions once you could detect cardiac activity from the fetus, basically around 6 weeks. And the interesting way that it's enforced is basically, instead of being enforced from state officials, it allows any person to sue any person who performs post-heartbeat abortions or who aids or abets them. And prevailing plaintiffs are promised at least $10,000 of statutory damages per abortion. So this was sort of designed to prevent certain challenges against the law. When the Supreme Court basically declined to strike it down, and they stressed basically looks like they declined on procedural grounds. Could you sort of elucidate the situation for us with respect to what the Supreme Court said and where this case is likely to go?
Yeah. So what happened was the Supreme Court, as you said, declined. They didn't decide to not strike down the law.
Right.
They decided not to take the case to stop it from coming into effect. And that's different than a finding on the merits. Mm-hmm. And in fact, the order says we do not make a ruling on the merits. This is unusual in the sense that many restrictions against abortion are often stopped by a court before they take effect. And the Supreme Court often weighs in on that, saying that decision is appropriate and holds the act from stopping to become effective until there's a litigation about the case and whether or not the abortion restriction is constitutional. Now, we have in the country a jurisprudence which is somewhat murky about the right to an abortion, but basically there's a recognized right to have an abortion, and that no state can impose, or a federal government can impose what's called an undue burden on that right. What an undue burden is has been murky.
Right.
And so, some things are not undue burdens and other things are. This Texas law is very unusual because it's very clever. I'm not sure for the good or for the ill, but it's very clever because it's not enforced by governmental authorities. It's enforced by civil litigants. So, and apparently anybody, I'm not sure if it's just people from Texas or anybody, can say, can sue to stop someone from obtaining an abortion, or at least they can sue the providers the medical providers that would perform the abortion. And so, and if they do successfully stop somebody, they get a $10,000. The people that oppose it call it a bounty, and they say they're bounty hunters. I'm not sure what's the phraseology in the legislation, but they get $10,000. Mm-hmm. So, an incentive to do this. Normally, when up until this point, when an anti-abortion law has been passed, or a pro-life law has been passed, it's enforced by the government. And so you know who to sue, and you can get an injunction against it from coming into effect. Here, you don't. Who do you sue? You sue everybody in the state of Texas.
Right.
So there's this enforcement issue. Now, on the other side of it, someone could say, well, I'm going to ban handguns in the state of Texas, and we're not going to let the government enforce that. We're going to let private people enforce that. So you can sue somebody that has a gun, a handgun, and you get $10,000. So you always got to look at it both ways. Do you really, is this clever mechanism something you really want to have in the law forever? Because maybe Texas isn't going to pass that law, but New York City might. They already tried to do something very similar to that. So whether or not the courts just put that aside, or that's a new area of litigation, it's going to be very complicated. But they haven't made a decision on the merits. And the way that I see this happening, one way, there's others, is that somebody finally sues one of the operators or an individual that wants an abortion, and then there's an emergency hearing, and then there will be some kind of decision that comes out about whether or not the heartbeat law is an undue burden or not.
Right. Going back to the Casey decision, right?
Right.
Yeah. Yeah. Have you seen this? This is a very interesting mechanism. Have you seen this play out before? This sort of enforcement?
I have not. I mean, there are areas. There's one area in Michigan that's a little funky, where there's a termination of parental rights. So if somebody is neglectful or abusing their child, the state can come in and terminate the rights. But private people can also do that, which when I only did family law for 1 year, but I was always surprised. It didn't happen a lot, but I'd get a case where some interested person, wants to terminate the rights of an individual. And so I've seen it there. You could also, civil commitment of mentally ill people is usually brought not by the state, but by a relative, where they say, my father or my brother or whatever is going to hurt himself, and they go to court and they petition the court for that commitment. So those things do happen in other areas. Whether or not that changes the constitutional analysis, I don't know. I haven't given. Thought yet.
As I said that, I was just reminded of in California, you can a private citizen can sue employers for things like wage violations and things of that nature on behalf of the state and enforce it. So that's somewhat of a corollary. The last question I have for you is regarding the issue with big tech, Facebook, Google, etc. This is obviously this is currently and will be one of the most hot button issues for next several years, and we don't know exactly how it's going to play out. There are two components to it. It's actually bipartisan in drawing ire from both sides, institutions like Facebook and Google. There's an antitrust aspect, which finds that entities like Google are basically using their market power to hurt consumers by destroying other competitors. There is, and also Facebook as well. There is issues from the right wing, which basically deem that these institutions are playing the role as almost quasi-state, quasi-government actors. They're obviously, Democratic politicians, for example, have told Facebook and Google and Twitter what to do under testimony and have threatened them. And then they've gone and done certain things in terms of prohibiting certain people from the platform. So you can find state action there. There's also the concept of them, being the marketplace, being the sort of central town square, for example. There are people who think that they can be regulated as utilities, and maybe that's the answer to sort of stop their ability to discriminate against people if they're regulated more like public utilities, and that entails prohibitions on being able to discriminate against certain people and how they can operate and things of that nature. How do you sort of see the merits of the arguments against big tech from both maybe a antitrust corporate perspective, and also from a them acting as a quasi quasi-governments, and therefore, they have to abide by the First Amendment. How do you make sense of all this?
I'll tell you, this is one of the most fascinating issues that we have come across. And what we, the law is usually a laggard. The technology, as is morality and ethics. So the technology often outstrips the ability of the law or ethics or moralists to get theologians as well to get a hold of what's going on. So here is one of those circumstances. One easy way to look at this is that despite all of its market power and despite its dominance at this moment, the bottom line is social media is still private owned. And that they should have the ability, like any other privately owned institution, to determine the content of what happens on their platforms, and that there's these user agreements that people are expected to follow. And if Facebook doesn't want to post pro-Trump stuff, that's their constitutional right. In fact, it would be unconstitutional to force them to have to foster speech they don't like. It would be like me saying to you, Ashton Cohen, you have to host, now that you've had Judge Warren, now you have to have a jurist who is very, very progressive on and explain their position. We used to have that with the FCC. We used to have a rule on TV that you have to carry certain content, and you had to have a balanced view, because the airwaves were a public utility, because there was finite. The FCC would issue you a channel or a license to broadcast, but because it was really the public airways, you had the responsibility to carry both sides. They got rid of that several years ago, and because of cable TV and other developments. And now that's why you have Fox News versus MSNBC, right? Because they don't have to follow the fairness doctrine, that's what that was called, or other requirements. In the cyber world, they would say there's this unlimited bandwidth that you could have. There are other opportunities for conservatives or communists or fascists, whatever it is, to create their own platform, and you shouldn't force them to, just because one's particularly big and they're successful doesn't mean that you require them to have to carry content they don't agree with. Of course, the reality was there was Parler for like a nanosecond, because everybody said, "Oh, create your own network if you want to." They did, and they shut it down. They being, the service entities. So you see that and you go, okay, well, maybe these folks are the new public square. And the public square means that you can't have what's called content-based restrictions. Mm-hmm. So if you go on a park that's a public park, you can have what's called time, place, and manner restrictions, and you can't give speeches at midnight with big, huge, blaring speakers, but you can go there, between noon and 8. And if you're going to let anybody speak there, then anybody can speak there. You can't deprive them based on their content. So you can't say, well, we only want Republicans to speak here, or libertarians or Green Party people. You can't restrict if you allow anybody to speak. So there's been some, that's going to be the real question is, are the platforms like Facebook and Twitter, mm-hmm. And others, are they so big and so dominant that they in essence are becoming the new public square?
Right.
Or are they more like the mall? Because there was some mall back in the 70s. Some people don't even remember there were malls. Back before Amazon and all that stuff, you'd go, and Michigan is the birthplace really of the modern mall movement, the closed in structure, because it's so cold in the winter. That you'd go into the mall, and that's where most people went to shop. And so people would start handing out literature, and there were lawsuits over that. And at one point there was a ruling that said, well, they're the new public square, So the mall owners lost control over what could be distributed. That was reversed, and it was determined, now and forevermore, at least as of now, that mall owners don't lose their ability to control the content, and so they can kick people out if they're just the Hare Krishnas or something like that, trying to evangelize. And so, and airports, which is a public entity, most of them, but they even said they can have these restrictions. So unless there's a real change in jurisprudence, and there could very well be, but unless that gets changed, I think it would be hard for a court to rule that they've morphed into a public utility. So public utility is your water, your electrical, whatever.
Essential services. Yeah.
Just because you're a Nazi doesn't mean you don't get electricity, right? Everybody gets their utilities. And so the theory is, well, social media is the new utility, and it's so essential to modern life that it's just like electricity or water service. And I'll tell you, for the kids that I talked to this morning, the 8th graders, there's no question they view it that way, right? This stuff is like part of their identities and their lives. It's central to that. For other people like my parents, they don't even have Facebook, so it's not essential. So it's a really interesting issue that the court will have to grapple with.
It is interesting. So one way to look at it is Facebook, which has 1/3 of all humans on Earth on its platform, right? So it's something like over 2 billion accounts. And then you add an Instagram as well, which it also owns. Is that more like a modern town square, or is that more like a mall? And I think if you look at it that way, it seems to be more the former. And as far as it's being essential, these it would be interesting. I think so. Kennedy in when he was in the Supreme Court mentioned this in his dicta, basically saying that, these are private entities, but they're not like your typical private entities. Thomas has hinted at this as well in Supreme Court decisions. And I'm immediately reminded of, I think it was Marsh versus Alabama, where it was like a company town back when company towns were kind of a thing. And the Jehovah's Witnesses were putting up, their religious literature on the town bulletin board. And I forgot the entity in question, the company was like, well, no, you can't do that. And the Supreme Court said, no, actually, you guys are kind of acting like you're as a state actor, you're quasi government actor in this situation, and so you can't prohibit them. You're bound by the First Amendment as well. I think that I haven't seen that argument made as much. I don't know if you have thoughts on that, but I think that kind of approach seems to make sense to me as a corollary.
Well, that is a very interesting case, and in some cases are what we call sui generis, which is unto itself, it's unique and might not really have application to others. And some people like to talk about any case involving the Amish, right? Because they're so sympathetic, and they're trying to protect the lifestyle of the Amish, and so they get like these special exemptions which would never apply to anybody else, but they're the Amish.
Right.
One could argue that the company town is like that it's so rare, and that it's really so unique that it isn't good precedent for other places. And so if you live in a town that's owned by a company, everything is owned by the company, the homes, the stores, the roads, the whatever, then it in essence has become the government, and therefore this kind of ruling applies. So I think, the argument is there, and it could be made that, but it would almost be as if, I think it would be a much stronger argument if you had one entity that controlled all of the internet. And that, it probably existed in the past, right? You had one entity
It's
that
arguably
was,
Google, I mean, if you really think about them being like the gateway to the internet for
yeah, but you have
almost everyone in the free world.
DuckDuckGo. I use DuckDuckGo. I don't use,
So is that
so
like a 3% market share though?
you got it. So, but there's nothing stopping you from doing that. So if the internet was owned by one entity and there was only one social media platform, much stronger argument for the company town than a lot of different platforms with the government really used to created the internet. I think now it's in a whole bunch of different people's hands. So I'm not saying it's a credible argument, but I don't know that it would carry the day in the end.
Yeah, I think there are a couple more. There are a couple. That was just sort of what I was reminded of. I think there are probably a couple more compelling areas that you could draw a link to, including examples of Democratic legislatures, telling Facebook and Google, this is what you got to do, and then they do it, and then holding to the standard. Well, a government telling a private corporation to do something that the government can otherwise do, maybe an example, state action. I'm still sort of looking, I'm still sort of educating myself on the different ways, because it is complex and it's unique, and it's very interesting.
Yes, absolutely, absolutely. Right. So it will be, I don't think the Supreme Court has anywhere near resolved. I don't think we can read any tea leaves, I guess, on this and make a decision about how this is all going to turn out. I think that's true.